Qualified immunity is a legal concept that protects law enforcement officers from being personally sued for damages in civil lawsuits. It means that officers are shielded from liability if their actions were taken in good faith and they reasonably believed their conduct was lawful. However, if their actions violated a clearly established constitutional right, they can be held accountable. In simple terms, it gives officers some protection from lawsuits as long as they didn't knowingly violate someone's rights and acted within the scope of their duties. But where did it come from? Qualified immunity was established by the Supreme Court of the United States through a series of cases. Two key cases are: 1. Pierson v. Ray, 1967. In this case, the Supreme Court recognized the concept of qualified immunity for the first time. The court held that law enforcement officers performing discretionary functions are entitled to immunity from civil damages as long as their actions were taken in good faith and they had a reasonable belief that their conduct was lawful. And 2. Harlow v. Fitzgerald, 1982. This case further clarified and refined the doctrine of qualified immunity. The court ruled that government officials, including law enforcement officers, are entitled to qualified immunity from civil liability unless their conduct violated clearly established statutory or constitutional rights of which a reasonable person would have known. These cases, along with subsequent decisions by the Supreme Court, have shaped the doctrine of qualified immunity. It is important to note that the specific scope and application of qualified immunity have continued to be clarified and modified through subsequent cases and judicial interpretations.